Hi, I'm Abby, and my Supreme Court case is on New York Times Company versus Sullivan. L.B. Sullivan was an elected official in Montgomery, Alabama, who was offended by an ad and sued the New York Times Company. Sullivan's argument was he had been libeled, meaning a published false statement that is damaging to a person's reputation, by the advertisement titled "Heed Their Rising Voices," which was in the New York Times newspaper on March 29, 1960. This text had an appeal for funds for the support of the student movement, the struggle of the right to vote, and the legal defense of Martin Luther King Jr. against a perjury indictment. The names of 4 individual petitioners and 16 other people, majority of which were clergymen from different southern cities, were stated in the advertisement. The ad was signed "Committee to Defend Martin Luther King and the Struggle for Freedom in the South" at the bottom of the page. Sullivan was the Commissioner of Public Affairs and supervised the duties of the Police Department, Fire Department, Department of Cemetery, and Department of Skill in Montgomery, Alabama. Thus, when the advertisement made some false statements about police action against students participating in a civil rights demonstration and against a civil rights movement leader, Sullivan sued with the argument that the statements were a reference to him because of his supervision over the police department. Sullivan sued against the 4 individual petitioners mentioned in the newspaper and the petitioner of the New York Times Company. In the Supreme Court of Alabama, the trial judge told the jury that certain statements were automatically considered harmful and proof of actual damage was not required. He also said that the statements were proven to be published by the defendants and related to the plaintiff. The jury can award compensatory damages with malice presumed. However, the judge didn't require proof of intent or recklessness for punitive damages, only negligence. The jury ruled in favor of the plaintiff, and Sullivan was awarded $500,000 for damages. However, the Times took the case to the Supreme Court, where the ruling was 9-0, meaning that Alabama's court verdict violated the First Amendment. Justice William J. Brennan Jr. concluded that in this case, under the First Amendment, the press could not be liable or liable since there was little evidence provided. That statements in regards to a public figure, that falseness is not sufficient to become a liability. However, the evidence must display that the statements made were with knowledge of its falsity or reckless disregard of the truth. To encapsulate this standard, Brennan used the term actual malice, meaning it's about knowingly spreading false information or showing a reckless disregard for the truth. The ruling was in favor of the newspaper. The Supreme Court concluded that they had the right to publish all statements under the First Amendment. Under the First and 14th Amendment, the 14th guaranteeing equal protection under the law to all citizens, it also ensures that states cannot deny any person within their jurisdiction the rights guaranteed by the Constitution. A state cannot award damages to a public official for false statements that are defamatory and may relate to their official conduct unless evidence of actual malice is provided. Ultimately, the Supreme Court decision guarantees the freedom of speech and press through the First Amendment. The First Amendment protects the freedom of speech, the press, assembly, and the right to petition against the government. Defamation is the action of damaging the good reputation of someone. Thank you for watching, and this was a Supreme Court case on New York Times Company versus Sullivan.